Hello, and welcome to Move or Improve with Debbie. I'm Debbie Miller, your host for today. And I wanted to follow up with a previous podcast we did on inheriting your parents' assets. In other words, what to do with all the stuff that your parents left behind when they pass. And with me today is the same person who was with me then, and she's excellent. Michelle Chapin specializes in estate planning, estate and trust administration, and those sorts of topics. And so she is recognized as a top trust and estate lawyer in Washingtonian Magazine, and she excels at providing clients with easy to understand explanations of intricate legal and tax matters. And so I really wanted to have her come back to pick up part 2 of this, which is talking about protecting your children's inheritance from creditors or in the case of divorce. So welcome back, Michelle. I appreciate your joining me today.
Thanks for having me, Debbie. Yeah, I'm happy to be here.
Thank you. Let's just get right into it, because in the previous podcast, we did talk about setting up a trust as a way to avoid a lengthy probate process. But can creditors go after a trust?
Creditors can go after a trust the same way that they could go after assets of an estate. So there's a big discrepancy in how trusts can provide protection. They can provide protection provided they're set up in a certain way. And so we have to distinguish between revocable trusts, which are a will substitute, and irrevocable trusts, which can provide creditor protection. So oftentimes what people do is they'll set up a revocable trust while they're alive. And while they are alive, the revocable trust you set up is not protected from creditors. Okay, it's just a will substitute, and it says, at my death, here is where my assets go. It has some other bells and whistles where you can have some incapacity planning using a revocable trust. But as far as creditor protection, you don't get it with a revocable trust, because you can amend it, you can change it. And so therefore creditors can absolutely attack them. However, if you set up an irrevocable trust, then there is a great possibility of having creditor protection. And the reason I say a possibility is that if you set up an irrevocable trust for the sole purpose of avoiding creditors, then they can attack the trust if it's within what's called a look-back period. So what most people do, if they're really trying to protect from creditors while they're alive and they don't actually have a creditor currently, they can set up a trust that is irrevocable for their benefit and the benefit of others. This is called a domestic asset protection trust, or a DAPT. And that way you can protect from creditors that you may have in the future, so long as you didn't have them when you created the trust. There are also trusts that can be created at your death. So for example, most commonly this is seen with revocable trusts. So I put all my assets into my trust while I'm alive. It's revocable. When I die, it goes, let's say, to my spouse in a marital trust, or to my kids in an irrevocable trust. Those trusts created upon my death, whether they're from a will or a revocable trust, those trusts are then irrevocable. And that's called a third-party trust, created for someone else's benefit. So not created by the person, but created by a third person. And those are also irrevocable and protected from creditors.
Interesting. That's a lot to absorb and think about, but it makes good sense. So, but an irrevocable trust can't be changed or modified, is my understanding. Is that correct, or have I got it wrong?
For the most part, irrevocable trusts are irrevocable and they cannot be amended or revoked. Mm-hmm. There are some concepts that have been breathed into the law that allow for certain changes within an irrevocable trust. So, for example, let's say the law changes and trusts are in the future taxed in a way that is very harsh and onerous, and it would obliterate the purpose for which the trust was created. If it was created for creditor protection and now taxes are going to destroy the trust, there is a way to incorporate something called a trust protector, which is a person that can amend the trust to deal with unanticipated things like that, like law changes. There's There's some other things that are probably beyond the scope of this particular podcast about ways to amend trusts and terminate them, not revoke them. But for the most part, you should think of an irrevocable trust as irrevocable, that cannot be changed or modified unless there is a great need, and sometimes court approval is needed to modify the trust.
Oh, that's great. So how long do creditors have to collect a debt from an estate? Obviously, it depends on what state you're in, and certainly listeners should check with an attorney in this particular niche in their own state. But do you have just some general information you can provide on that?
Yes, I agree. Everyone should check with their own state laws with respect to creditor periods, because they do vary. They're a state law concept. But I practice in Maryland, Virginia, and DC. And so when someone dies, we look at, well, was there an estate opened, a probate estate, where the court has to oversee the process of administering that person's estate, or was everything in a trust? And then do the trust creditor periods apply? Or is there some of both, because some of their assets go through the estate and some of their assets are titled in the trust? So we have to look at all of those things, and they vary in each state. So for example, in Virginia, if you have an estate opened, there is actually no specific creditor period upon the death of someone. And so we look to what the state statute of limitations was, which is generally 3 years, although not for every single cause of action. In Virginia, a personal representative can actually distribute assets, even though the creditor period has not completely run, after 1 year without personal liability. So oftentimes in Virginia, personal representatives will not make distributions to beneficiaries until a year has passed from the decedent's death, because they don't want to have to be personally liable for repaying a creditor who hasn't made a claim while the period's open. The claim period is open. Mm-hmm.
But I just want to interject real quickly, just in case listeners don't know, what's the difference between a personal representative and an executor for an estate, or is there a difference? Is it one and the same?
They are one and the same. They're synonyms.
Great. Okay, move on.
Sorry. And then
I wanted to make sure we had that clear, because I know some people think of it as an executor or an executrix, and then personal representative is the same thing. It's just a matter of clarification.
That's right. They're the same thing. The creditor period in Virginia for a revocable trust is 2 years. And why the difference between a 3-year statute of limitations if something was owned in a decedent's sole name and passes through the decedent's estate, and why there's a 2-year period if it was titled in a trust, doesn't really make sense. They should probably be similar periods, but that's what we have to deal with. And interestingly, in Maryland and DC, the creditor period is much shorter than in Virginia. In Maryland, if you have an estate opened, the creditor period is about 6 months from date of death of the decedent, or if you give notice to creditors, then it's shortened to 2 months from the delivery of that notice. For a trust, it's 6 months after date of death or 6 months after date of publication to notice to creditors, and that depends on whether you have what's called a regular or modified estate administration or a small estate proceeding. So they're similar periods, but they're not exactly identical, since they're 6 months from a different intervening factor. So you just have to be careful and look at the statute. And then in DC, it's similar to Maryland. It's 6 months after the date of publication of notice of the personal representative for an estate. And for a revocable trust in DC, it's about 6 months from date of notice of publication.
Interesting. Okay, so can you really leave your child out of a will? Do you have to name them in the will, or is it possible to do that if it's a scallywag type of person and you just are fed up with them?
Absolutely. You can disinherit a child. You have no obligation to leave a child anything. In fact, you can leave your assets to anyone for any reason, and the only person that could ever possibly complain is a spouse if you disinherit a spouse, because you cannot disinherit a spouse in America unless the spouse allows themselves to be disinherited, either by signing a prenuptial or postnuptial agreement, or by not filing a claim against an estate. So I see parents all the time who, for whatever reason, they are either estranged from a child, or they've lost touch, or their child is wealthy and doesn't need the money. For a whole host of reasons, they will leave a child out of an estate plan. And oftentimes what we'll do is we'll still name the child, and we'll either define them either not as a descendant, so that the provisions that do provide for descendants would not include that child, or we'll say something like, for reasons best known to me and not out of a lack of love or affection, I'm not leaving anything to this particular child.
Interesting. So they better behave, or if they're an only child, that some third party will get a whole lot of money if there's anything left like that. So, I had an aunt once who passed away, and in her will, she listed every single person she could think of, all her nieces. And she said, nope, you're not getting anything. It goes to some other entity person who became an instant overnight millionaire, but nobody really cared because she was very difficult to get along with. And we didn't think it was worth being nice to her when she didn't appreciate it. So it does depend on what's going on. So about that and things that have happened in your transactions that you've handled.
I have seen interesting experiences with clients excluding a child. So occasionally it happens if someone is estranged, perhaps with an adopted child, more often than a biological child, but we've seen it both with biological children and adopted children. But I've also seen it where a client and a spouse, who's probably also my client, are married, and perhaps there is some other descendant, meaning a child or a grandchild out there that is not of the current marriage, perhaps from an affair. And in that case, we really need clients to be very honest about who is out there, because if I am saying in their documents, I leave everything to my descendants per stirpes, which is to a child if the child is alive, or the grandchild if there is no child living, then it's possible that this person that's not been part of my client's lives could have a claim. And so you really need to exclude a person if you know they're out there and they could be considered a descendant.
Interesting. So the child is entitled to an inheritance, but if you say no in the will, then they don't have any recourse, correct?
Well, if you leave your estate to your descendants, then they would be entitled because they're named as beneficiaries. And then the question becomes, who are the descendants? And does it include someone I didn't intend it to include, like this child I forgot that I had and didn't raise from a one-night stand or from, a prior relationship?
Mm-hmm. So that's how you would exclude. You'd have to very gently, well, you better be sure your significant other or spouse knows about this before you do it. And then the other children as well, if they are legally yours, then you have to disclose a little bit of everything, it sounds like. So you have to be
right.
careful. This is the time to come clean.
That's right.
Yeah. So you can exclude a child from your will, but can an adult child inherit the parent's debt? They may not want to be included in the will if they're going to inherit the debt.
Well, generally, we look at whether an estate is solvent or insolvent. And a child has no obligation to take over a parent's debt if the parent has an insolvent estate. But if the parent has a solvent estate, meaning the debts are less than the assets, so that there are some assets left over to distribute to the child, then those debts get paid before the assets get distributed to the adult child. There are instances, for example, where a parent has a home with a mortgage on it, and the mortgage actually does not have to get paid before the house can transfer